My presentation topic concerns competency to testify. Throughout my presentation, you will gain an understanding of the various tactics used to distinguish competency among different factors, including analyses and exams. To begin, competency to testify is determined through numerous factors of an individual when giving evidence in court. Specific factors can include psychological research through observation, memory, and suggestibility, as well as the ability to communicate, moral development, and conclusions. According to Melton, in 1975, the Federal Rules of Evidence added Rule 601, which simply implies that every individual is competent to be a witness in court unless their testimony is deemed irrelevant or likely to mislead the fact finder. Subsequently, if an individual is unwilling or unable to promise to testify truthfully, he or she will be dismissed from testifying. It is essential to recognize that evaluations of witnesses stand on a different footing than evaluations of litigants. Now that you have a grasp on the concept of competency when testifying, my discussion question touches upon how traditional versus modern viewpoints regarding competency to testify differ, and what factors should be considered by the court. This question will explore both viewpoints, noting their differences and similarities, to inform conclusions about competency. The comparison of competency is distinguished between traditional and modern. Traditional competency is featured through the common law. A presumption is noted for all individuals associated with a disqualified category. Specific examples of a disqualified category can include convicted felons, children, individuals with mental disabilities, certain religious beliefs, and spouses of parties. For instance, until the 1970s, the law in most states presumed adolescents under a specific age were deemed incompetent to testify. In other words, the particular party representing an adolescent had to prove competence. Now picture this. Children as young as 4 years old have been found competent to testify. In 1988, the case of State versus Cavett concerned a sex offense with a 4-year-old child. As the victim began to recount the events that occurred, the judge and jury deemed the child competent as it related to the case. Ask yourself, at that age, would a jury or judge deem you competent? A primary test determined if an individual was barred from testifying if he or she fell under a disqualified category. Moving on to modern competency, this is seen through the Federal Rules of Evidence. This means competency is presumed for everyone. Having said this, no disqualifications are imposed. The case-by-case determination involves an individual's ability to perceive, recall, and narrate a series of events regarding the specific situation. There is no presumption of incompetence based on an individual's factors. Instead, each court will assess the individual to ensure all minimal competency requirements are met. After contrasting both definitions and forms of competency, I have determined that traditional competency is more restrictive regarding deeming an individual competent, while modern competency is more lenient. Furthermore, traditional competency focuses on one's credibility to speak under oath, whereas modern competency allows the credibility of the individual to be decided through the jury. Moving on to specific factors to consider, there are various that need to be established by the court to determine competence. For example, for a child to be deemed competent, there are numerous requirements. The child must possess the capacity to observe various events, recollect and communicate them, understand questions, craft intelligent answers, and have the consciousness to speak the truth. Knowing right from wrong and having sufficient mental capacity to understand and process information about the facts as they relate to the testimony are essential. The court will assess the individual to ensure they understand the nature of an oath and moral, legal obligation to be truthful. Thank you for taking the time to learn a little bit more about competency to testify regarding various variables and individuals within our court system.